All right, pause for a second. Notice how the judge carefully reminds the witness to say yes or no. That's not just formality. In court, every word must be recorded precisely.
Anneau hors à meuble.
Legally worthless. It's all about a clean, official transcript. Scroll hashtag courtroom facts.
Wa.
Good morning, sir.
Good morning.
How are you?
I'm good.
Would you please raise your right hand for me? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can have a seat. And I'll just ask if you'll do your best, kind of pull that microphone. Be sure to speak loudly and clearly so we can all hear you. Also, if it's a yes or a no question, be sure to say yes or no, not just an uh-huh or a head nod so the court reporter can take everything down.
Yes, ma'am.
Okay, you may proceed.
Okay, while we're here today, right?
Yes, sir.
Turning your attention to May 17th of last year, were you at the S&S grocery on Concord
Yes, sir.
a little bit before noon?
Yes, sir.
What were you doing
I had just received a call from my boss man. I was driving a tow truck and I was sitting in the parking lot putting the address in for my next call when I witnessed the guy chasing another guy with a gun.
there? Okay, would you describe for the court, describe the man who had the gun. What did he look like?
Black male, he had braids, and he was driving a blue or purple Lincoln Navigator.
Kind of a dark color,
Yes,
blue, Lincoln Navigator.
Yes, sir.
What did the gun itself look like?
If I'm not mistaken, it was black and chrome, if I'm not mistaken.
Okay.
Yes, sir.
And what was the man who was driving the Navigator, what was he wearing?
I don't recall from the clothing at the time.
Okay. Do you remember if he had a shirt on at all?
If I'm not mistaken, I believe he didn't have a shirt on at the time.
Didn't have a shirt, just had
Yes,
on
sir.
jeans.
Yes, sir.
Okay. Did he, what was he doing with that gun?
Chasing the guy pointing at the guy at the store.
Okay.
Chasing
And the
him
guy
to
he
the
was
store.
chasing, what was he wearing? Do you remember?
No, sir, I don't remember. No, sir.
Okay. Were you there when the police arrived?
Yes, sir.
And what happened at that time or shortly before that time?
The officer pulled into the driveway, activated his lights, and the vehicle drove around the pumps and took off on Concord.
Had the man who was driving that Navigator, had he stopped chasing the other man with the braids and got in his vehicle?
Yes, sir.
And then when the police arrived, he was in the vehicle already?
Yes, sir.
And when the police got there with their lights on, he didn't stop, he kept going.
He just shot out the parking lot and kept on.
Did he fire the gun at the man?
No, sir.
But he brandished it, you could see the gun.
Yes, sir.
Was the other man running from the man with the gun?
Yes, sir.
What did the man running from him do? Did he go into the grocery store?
He went into the, I think it was the barbershop next door. He ran in there.
Okay. And for the judge, you've got the grocery store kind of on one end, and then you've got a couple other businesses there, right?
Yes, sir.
And there's a barbershop.
Yes, sir.
Now, did the man in the Navigator, did he kind of drive around that parking lot kind of chasing him, or did you
Yes,
see
sir.
him just out of the vehicle?
He drove around for a minute, and then, if I'm not mistaken, he had parked in front of the store for a second and started chasing.
Okay.
Yes, sir.
And this didn't look to you, did you know either one of these people?
No, sir.
Did it look to you like this was some kind of a game or play acting?
No, sir.
The man running from the gun appeared to be afraid.
Yes, sir.
The man with the gun appeared to be angry.
Yes, sir.
And this happened in Beaumont, Texas.
Yes, sir.
That's what it's doing.
Thank you.
Hi, Mr. Price. I was writing when he first started questioning you. When, on this May 17th, did I misunderstand you when you first saw this man who didn't have a shirt on, were you sitting at the grocery store parking lot?
I was sitting inside my tow truck, yes, sir.
On the parking lot of
In the
the
parking lot.
grocery store?
Yes, sir.
And that's the first time that you saw somebody chasing,
Yes, sir.
or a man with no shirt chasing somebody, is that correct?
Yes, sir.
And are you certain of that, of everything else you testified to here today?
Yes, sir.
Do you remember giving a written statement?
Yes, sir.
Okay. Did you remember telling the police that I was going south on Concord, going to a call, and that's when I seen a black male with no shirt chasing another black male with a handgun at the blue car wash on Concord?
Yeah, they started.
Did you make that statement?
Yes, sir, I did.
Okay. Do you agree that that statement is totally inconsistent with your testimony that you just gave when you just told the judge?
Signes
First time
escalade
you saw that
fastive.
man, you were
A
sitting
tow
in
truck
your
driver
truck
witnesses a
in the
gun
parking
chase in
lot
broad
at the
daylight outside a grocery store.
It was the first.
Imagine that scene, mid-shift, GPS in hand, and suddenly you're watching what looks like a live-action crime thriller unfold.
Écarlate hashtag Courtroom Drama hashtag Real Life Tension.
First time you saw that man, you were sitting in your truck in the parking lot at the grocery store.
It was the first time, yes, sir.
Huh?
That was the first time. He chased him across the street.
So when you testified under oath earlier that the first time you saw this guy was in your truck when you were sitting in the parking lot of the grocery store, that was not true.
That was the first time I seen him. I actually followed him from the grocery store to across the street.
Maybe I'm not making myself clear. When you gave your statement, you said I was going south on Concord.
Yes, sir.
Which means you were driving your truck,
Yes, sir.
all right?
Yes, sir.
And you say that you were going to a call, and that's when I saw a black male with no shirt chasing another black male.
Yes, sir.
Okay, well, that can't be true if you were sitting in your truck in the parking lot of the grocery store. So which is it? Which is true?
I seen him at the grocery store first. He proceeded, he chased the guy from the grocery store to the car wash.
Okay, may I approach witness?
Sure.
Show you, call it D1. You recognize that statement?
Yes, sir.
Okay, and is that your signature?
Yes, sir.
Is that your handwriting?
Yes, sir.
Okay, and did you say in here that I was going south on Concord, going to a call?
Yes, sir.
That's when I seen a black male? So is it true that you were driving your truck going south on Concord?
I was sitting at
Wait,
the
let me finish my sentence. You can't take two people. You can talk at the same time. When you were going south on Concord, going to a call, that's when you saw the black male. Is that correct?
No, sir.
Well, why did you write that down?
I seen him at the grocery store. And they should have cameras, but I see it on the camera.
Well, did you write that down, that you were sitting at the grocery store? When you saw this guy?
Thought I wrote it down in there.
Well, isn't it true? I mean, you gave everybody the impression in your statement that you were driving your truck and you look over and you supposedly saw some
I
guy.
was sitting at the grocery store.
All right, so you keep interrupting me.
I think all that's been, it's all been asked and answered. And you can step back over here if you're done with that as well, please.
So you'd agree with me there's a big difference between you seeing somebody where you're sitting in your truck stationary as opposed to you driving your truck going south on Concord and seeing somebody chasing somebody. That's two different things, right?
Yes, sir.
Okay. Well, when you were driving your truck going south on Concord, like you said in your statement, and you said you saw some guy with no shirt chasing another one. I mean, how far away were you from the guy that was who had no shirt on?
I was sitting in the parking lot. I was in the parking lot where everything was going on.
Okay, so your testimony here today is that your statement that you gave here back when it was fresh in your mind is totally incorrect. Is that correct? This can't be both.
I seen him in the parking lot where I was sitting there.
Okay.
And that's when I called the police. He chased the guy to the blue car wash.
Okay, so
Then he went back to the S&S store. That's when the police arrived.
so we can just ignore what the heck you wrote down here that you were driving your truck going down Concord and saw somebody, you know, allegedly holding a gun chasing somebody. That just didn't happen. That did not happen. Is that correct?
That's the way you want to put it.
Well, that's what you wrote down, but now you're saying that's not true.
Mr. Hoffmeyer?
Is that correct?
That's how you want to put it.
Okay. Well, so now your testimony here today is that you're sitting in your truck in the parking lot of a grocery store.
They got camera footage there.
Is that so? How? And so you look and you see somebody with no shirt on chasing somebody where?
In the parking lot of S&S grocery.
So when you see him, you said you saw these two people, one chasing the other, actually in the parking lot where you're sitting?
Yes, sir.
Well, you say in your statement that you had to, he's chasing, I'm going south, see somebody with no shirt on chasing another black male with a handgun at the blue car wash. You don't say anything about the grocery store.
That's where I started at the grocery store.
Not at the car wash.
No.
But you told the police that it started at the car, you saw them, the first time you saw them, they were at the car wash.
First time I seen him was at the grocery store. They went to the car wash and they went back to the grocery store.
Okay. The first time you saw him was at the grocery store.
Yes, sir.
But yet you wrote in your statement that you saw, the first time you saw him was at the car wash. That's wrong, isn't it?
The first time I seen him was at the grocery store, at the S&S grocery.
Okay, but you would agree with me that that's not what you wrote here.
I'm not agreeing with you with anything.
Well, let me
Okay.
Mr. Smith, Mr. Smith, it's been asked and answered. I get it.
So even in the, well, how far away was the guy that you saw with no shirt? How far away was he from you at the time that you first met?
Hang on. It's really important that you let him finish his question all the way, then answer, because she can't do two. She has to just take one at a time, okay? So let him ask the full question, and then he'll give you an opportunity to answer. Thank you.
How far away was the guy with no shirt?
Here comes the classic defense strategy direct hit, hammering inconsistencies. Notice how the lawyer traps the witness between two timelines. Was he parked or driving when he saw the chase? Small detail, big consequence. Because in court, credibility is everything. Hashtag.
Well, you were sitting in your truck at on the parking lot of the grocery store when you saw him.
I'm here to the officer.
Here to where?
The officer.
Okay. And you say that you saw a handgun in his hand.
Yeah, if I didn't see one, I would never call the police.
I didn't hear you.
If I didn't see no gun, I would never call the police.
Well, how do you know it was a handgun?
You know what a gun look like? I know what a gun looks like.
So I'm asking you, how did you know it was a handgun?
It was a gun. I know what a gun looked like.
Okay. Well, how do you know, say, was it a pellet gun that looked like a handgun?
You think I was going to watch him shoot him and find out?
I can't hear you.
You think I was going to sit there and wait for him to shoot him and find out?
How do you know it wasn't some other pellet gun or something like that nature that looked like a handgun?
So you think I was going to sit there and let this guy shoot that guy and just sit there
And
and
not,
find out?
objection non-responsive.
Listen, so you'll get an opportunity to explain, I'm sure, in just a minute. Mr. Philip Smith will ask you some follow-up questions. So if it's a yes or no question, just say yes or no without the explanation, and know that you'll get an opportunity to tell what you need to, okay? Go ahead.
The point is, you never touched the handgun, right?
I wasn't with him. No.
So you never inspected that what you're describing as a handgun, right?
No. I seen
Okay.
it. I seen it
So
with my eyes.
you don't really know of your own personal knowledge if it was a handgun or not. You're
I
just
know.
assuming that it was a handgun
I know for a fact it was a handgun.
because that's what you think you saw.
I know that's what I saw.
Okay, but you did not inspect it to make sure that it was in fact a handgun. Isn't that correct?
If I seen it, yeah, I inspected it. I seen it. I seen it from my
Did
own
you grab the
eyes.
handgun and inspect it?
No.
All right. So is that the only time that you saw him, that when you're in your truck and you're in the parking lot of the grocery store, you see somebody what appears to you to be a handgun, and he chases this person to where?
It's the blue car wash.
The blue car wash.
Yes,
And how far away is the blue car wash?
About 100 yards.
Huh?
About 100 yards from the S&S grocery.
About 100 yards. Okay? Like a football field.
Almost, yeah. Yes, sir.
Okay, so about a football field away, and then from the car wash, what happened?
We got chased back to the S&S grocery.
On foot?
Yes, sir. The guy, he was in the vehicle and the other guy was on foot. Yes, sir.
Okay. So when you gave your statement that I was going south on Concord, going to a call, that's when I see a black male with no shirt chasing another black male with a handgun, you're saying at that time he was in his vehicle?
Yes, sir.
Okay, well, if he was in his vehicle, how could you see the gun?
He got out of his vehicle and chased him inside the barbershop.
Okay? And that's nowhere on your statement here. Would you agree with me?
Well, the officers told me, no, just keep it simple. That's what I did.
Okay. So from the car wash, he stays in his car. The guy goes to the barbershop.
Yes, sir.
Okay. And the guy that was in his car, what did he do?
He get out and try to chase him there, and they had some other people trying to stop it.
Oh, now there's some other people trying to stop it. So there's other witnesses.
There was other people there. I'm the only one called the police.
Okay.
I'm assuming.
So, and again, none of that is in your statement, and none of that, anything like that, is in anything that you told the police. You didn't tell the police about anybody else chasing this man.
Nobody else was chasing him. I didn't say nobody else was chasing him. I said they had other people out there while he was chasing him.
Okay. And so, are you saying that he chased him when he came out of the barber shop? You're saying that the guy was out of his vehicle or still in his vehicle?
He was out of his vehicle.
Okay, when the guy gets out of the barber shop, where does he go?
That's when he started running again.
And where did he run to?
He ran to the blue car wash.
Okay. And what did the guy with the car go?
He chased him down to the blue car wash.
In or out of the car?
Inside the vehicle.
Inside the vehicle.
Yes, sir. Inside the vehicle.
And then from there, he went where?
Back to S&S. That's when the police finally arrived and pursued.
So you're saying he went from the car wash
Yes, sir.
to the grocery store?
Yes, sir.
Do you remember telling the police that that the black male ran into the barbershop off of Concord while Randall sat in his blue Lincoln Navigator waiting for him to come out? Price advised that when the
Law and Order #witness testimony. Here's a turning point. The witness is getting visibly defensive, frustrated that the lawyer keeps pressing about whether it was a real gun. But this is critical. The law demands proof beyond doubt. If it could have been a toy or pellet gun, the whole case weakens.
black male with dreads left the barbershop, he ran to the grocery store and the guy followed him there in the vehicle. So what you told the police, what you're telling us here today are two different things.
Well, I don't recall what I fully told the police at the time, but I recall what's on my mind now.
All right. Is it or is it not true that while you're driving your truck on the way to the call, that you did or did not see somebody chasing
I
somebody?
seen him when I was sitting in S&S grocery parking lot.
Okay, that's not my question. My question is it or is it not true, like it says in your statement, that you saw somebody chasing somebody else while you were driving your truck going to a call?
Judge, I don't object. That's been asked and answered dozens of times.
It has. Sustained.
Pass the witness.
Thank you, Mr. Smith. Philip Smith.
Mr. Price, you were concerned that somebody was gonna get shot.
Yes, sir.
Concerned enough that you called 911
Yes, sir.
to alert them that a heavyset black male with no shirt was chasing another black male from the barbershop to the grocery store.
Yes, sir.
You called 911 on your own volition.
Yes, sir.
If you'd have thought it was a pellet gun, would you have done that?
Yes, sir.
If you'd have thought it was some act or some game that they were playing,
Yes, sir.
would you have done that?
Yes, sir.
So you thought this was real.
Yes, sir.
Do you see the person in the courtroom today
Yes,
that
sir.
was chasing the individual with the braids?
Yes, sir.
Would you point to him and identify an article of clothing he's wearing?
Right there. Yes, sir.
In the red jumpsuit?
Yes, sir.
I'm gonna let the record reflect he has identified the defendant in this case.
The record will so reflect. Anything else, Mr. Bruce Smith?
Nothing further.
All right. Any objection to Mr. Price being excused?
No, Judge.
No, Your Honor.
Thank you. You're excused. Thank you for coming, sir.
Yes, ma'am.
All right. Any other witnesses, Mr. from the state? Any witnesses from the defense?
No, Your Honor.
Okay. So argument from the state with regard to counts 7, 8, and 9. Well, let me start here. With regard to count 9, based on the evidence from Officer Powell, I am going to find count 9 true. I will have, you guys can make argument with regard to count 7 and 8. The state, you may go forward.
Judge, I would argue that count 7 should be found true by preponderance of the evidence because Mr. Price testified that at the S&S grocery, which is a 51% business, that he did see the defendant chasing another male with a handgun. He was descriptive enough to say it was heavy set, he had no shirt on, he was driving a dark blue Lincoln Navigator. That the police pulled up before he left that premises and followed him. We know from Officer Powell that he followed that same vehicle until it crashed out. Inside that vehicle, or the vehicle was obviously driven by the defendant in this case. Inside that vehicle was a silver or chrome pistol, just as he described. That was the aggravated assault, was exhibiting a deadly weapon in the course of chasing the victim in this particular case.
All right, thank you. Mr. Smith, the defense?
Your Honor, as to count 7, that has to be found untrue as to what evidence was presented. The law of Texas is that a person commits a UCW if they carry a handgun in a grocery store. It becomes a felony of unlawfully carrying a weapon in a licensed premise.
Are you talking about 7 or 8?
I'm talking about 7.
7's not the unlawful carrying a weapon on a premises. 7 is the aggravated assault with a deadly weapon.
Okay, well, I misunderstood you. I'm talking about the count of the unlawful carrying a weapon.
That's count 8.
All right, that's count 8.
And I'll cut that short. I don't believe I have enough evidence on count 8 with regard to the premises and what the percentage of is an alcohol premises and things like that. I don't know that there's enough evidence on that. So I'll find count 8 not true. Let's talk about count 7.
Yes, Your Honor, on count 7, we would argue that as we showed in the testimony from Mr.
Price.
That the statements that he made to the police and the handwritten statement that he made at the time of the offense are so inconsistent with his testimony here today that his testimony is simply not believable. In addition to that,
Direct hit hashtag legal insights. There it is, the big reveal moment.
The witness point straight at the man in the red jumpsuit.
These identifications carry massive weight, but juries also know memory can be tricky, especially under stress. Was this confidence or courtroom pressure? Thinking face.
You know, the testimony from Mr. Price that he saw somebody chasing somebody with a handgun. The best way to describe that is that he saw somebody with what he thought appeared to him is a handgun. That does not prove, as a matter of law, that that was a handgun. And so that evidence before the court that this man was chasing somebody else with a legitimate handgun, that proof is totally insufficient as a matter of law, and we would ask the court to find that to be not true.
Anything else from the state with regard to argument on that?
Judge, there was a handgun that was found in the vehicle. The fact that he chased him from business to business, both in the car and out of the car, certainly I think there's enough evidence to find him guilty of the aggravated assault.
Or find it true. So obviously, I just like a jury can make reasonable conclusions and deductions based on the evidence, and the level of proof necessary in a motion to revoke is obviously substantially less than that in a jury trial with a jury. I think the evidence from Mr. Price, the evidence from Officer Powell, there was no real lapse in anyone having their eyes on that vehicle and Mr. Randall at the time, from the call in to the cops getting there to him leaving and being the only person in the vehicle with the gun being found that matched the description of the gun, somewhat that Mr. Price saw and that Ms. Officer Powell found in the actual seat of the driver. I am going to find count 7 true. So that makes, there were pleas of true again to counts 1 through 6. I'm finding counts 7 and 9 true. So now, Mr. Bruce Smith, argument with regard to punishment. The underlying offense, just for the record also, that Mr. Randall is on a deferred probation for is aggravated assault causing serious bodily injury. That was a 10-year deferred probation. You may proceed.
Your Honor, we would argue that what my client pled true to in counts 1 through 6 are all administrative counts. We pled true to those, and they're all dated back in 2023. It's my understanding that he got all that problems straightened out, and that the probation department was fixing to put him on reporting like every other month rather than every month, which indicates to me that they thought that he had straightened out his act.
Where do you see that? Is that in the report?
No, that's not in the report. That's just my understanding.
Okay.
And the statement, as far as the pre-sentence investigation update, the statement indicates and verifies that my client has had, medical problems in the past. And they repeated that he was taking medication back at the time that he was having these problems back in 2023, and that the medication had an impact on him.
Hashtag Courtroom Watch, hashtag Justice News. Judge West lays down her ruling. Count 7, true. Meaning, she's convinced there's enough proof the defendant used a deadly weapon during the chase. Notice the calm tone, but make no mistake, this is a legal hammer drop.
Balance hashtag court verdict hashtag.
I want to make, that's what he said to them.
That's correct.
Okay.
Yeah. But I think the record as a whole in your file indicates that he did have problems, mental health problems in his past. In fact, was seen going to a local dental top and was on medication. In that, we would submit that was the problems back in 2023, and that since that time in 2023, it wasn't until we have these problems in 2024 that we have this motion to revoke. So we're asking the court to take into consideration the fact that for a long period of time he was having only administrative difficulties in his probation, and I think that's important for the court to take into consideration. Since the court made a finding of true as to counts 7 and 9, we're asking the court to, if it doesn't see fit to continue my client on probation, we're asking the court to, if in fact it does revoke his probation, that his sentence into the Texas Department of Criminal Justice be set at no more than 5 years.
Thank you. Mr. Philip Smith?
Judge, we filed our first motion on December 8th of 2023 after he had been an absconder for several months. This offense occurred.
Your Honor, I would object. There is no evidence of him being an absconder for this court.
It's in the PSI, and you had no objections to the PSI. He failed to report February 20. He pled true to failing to report February, May, June, October, and November of 2023.
Yeah, that's correct, Your Honor. But I mean, absconder means he just disappeared.
Well, he did disappear. They didn't see him.
He admitted that there were certain days that he did not report, and those were the dates that he did not.
You did not
report.
object to the pre-sentence report, which also we have the. You're the probation officer, correct, Ms. Bryant? Yes, ma'am. Would you please come up? Good morning, ma'am. Well, good afternoon. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And I'm going to do this a little informally. We're not going to get into a whole lot of questions. You stated in the updated pre-sentence report that after the defendant had not reported for more than 90 days that he was changed to an absconder status December 5th of 2023. Is that correct? Yes. So from February until then in December, February of 2023 to December of 2023, how many times did Mr. Randall report? And if it's helpful, you can set your stuff down on the podium or whatever up here with whatever you need.
You said from February of 2023?
To December.
Four.
Okay, and when was the last reporting?
2023 was August 10th.
Okay. All right. So once you hit December and that 90-day mark is when you guys changed it to absconder, and that's when that motion was filed and administrative hearing was done, correct?
Yes, ma'am.
What about any information that you have with regard to Mr. Randall participating in Spindletop services?
Me personally, I don't have any information. I wasn't an officer at the time.
Okay. Is there anything in the file?
Justice System.
And now we enter the emotional final act, mitigation versus accountability. The defense pleads for leniency, citing mental health and medication, while the prosecution paints a picture of repeated defiance.
This is where justice meets humanity. Cœur brisé.
That you can tell that shows.
Give me 1 second.
Yes, ma'am. And when did you become his officer?
March of this year.
March of this year. So you weren't his officer back then. You're just going by what this. Okay. All right. That clears up the absconder. Go ahead.
Judge, one of the last times he did report before absconding was July 3rd, which I gather UA and he tested positive for methamphetamine. So we know he's committing multiple felonies over the course of being on probation for a felony offense. He is not a suitable candidate for probation. As the PSI officer stated, they have no desire, they believe the defendant has no desire to comply with the conditions of probation, and he's exhausted all appropriate sanctions and available programs. So we would feel like the only thing left to do is to give him appropriate punishment. We would ask you to take the facts of the underlying crime into consideration. It is an aggravated assault. He has committed another aggravated assault with a firearm this time, and we feel like no less than 16 years in prison would be appropriate in this particular case. So that's what we're asking.
Thank you. Okay, so I just want to go through, Mr. Randall, one of the reasons why I asked the probation officer some specific information about whether or not you had reported during that year, which you did, and it's actually in here. You reported March and April, in July, and then again in August. And you were given information on those about the anger management class. You made a statement that you were taking medication that made you forget about your probation. But, okay, so, but you showed it. So it's not like you started taking medicine and you never showed up. You did show up some of those times. So I've never heard of anyone having any type of medication through Spindletop or otherwise that makes them forget about going 1 week but not forget the next week. You were given, you just quit going to probation. Tested positive for methamphetamine back in July of 2023. Had one more appointment after that, stopped going, and then you're running around chasing someone with a gun and evading on foot and in a car. The underlying offense, and when I look back at that pre-sentence report, the fact that you were given a probation on this case in the first place was a big deal because you have a ton of history out of Louisiana. And so you were given you've had a 15-year sentence in Louisiana. You've had 3 years, 18 months. We've got a couple of times where they couldn't figure it out because Louisiana's not always easy to figure out. You had a probation just in 2021 that was revoked on a driving while intoxicated, and we still gave you a probation after you did what you did to Miss Edwards. Threw her around, hit her in the face, threw her where she hit her head, had to have stitches. Sometimes I look back on these and I wonder why I gave probation in the first place. At this time, I am going to find again that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Also find counts 7 and 9 true. finds sufficient evidence to find you guilty, and at this time finds you guilty of aggravated assault, family violence, sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. This is not an agreement. You do have some rights to appeal. I'm going to hand you the trial court certification. Mr. Smith, y'all need to get that signed, please, so I can get him a copy after I sign it. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Smith. And then, Mr. Smith, did you already file in the other cases motions to withdrawals or not?
I did, Your Honor.
I'm sorry?
Yes, I did.
Okay, so let's go ahead and get that taken care of. Mr. Randall, what I'm going to do at this point is I'm going to grant Mr. Bruce Smith's motion to withdraw from those other 3 cases. I will appoint someone today who can begin representing you on the other 3 cases. They'll talk to the state, see if there's anything that can get worked out. If not, we'll get those cases set for trial. And Mr. Smith, you are released on all 3 of those cases.
Yes, Your Honor.
All right, and then as soon as you get that signed, I'll sign it and give you all the copies of that. All right, court is in